This episode is brought to you by LifeLock. Between two-factor authentication, strong passwords, and a VPN, you try to be in control of how your info is protected. But many other places also have it, and they might not be as careful. That's why LifeLock monitors hundreds of millions of data points a second for threats. If your identity is stolen, they'll fix it, guaranteed, or your money back. Save up to 40% your first year. Visit lifelock.com/podcast for 40% off. Terms apply.
Today's episode is brought to you by SalesCred Pro, the strategic resource for B2B sales that fortifies your credibility and accelerates the trust building needed for building successful business relationships. Get your free 7-day trial now at salescred.com/pro. Welcome to the Manage Smarter podcast with hosts C. Lee Smith and Audrey Strong. We're glad you're here for discussions on new ways to manage smarter, hire, develop, and retain talent, improve results, and propel team performance to new heights. This is the Manage Smarter podcast.
Lee, as you know, I came out of the television news industry and the editorial side of media. You started out in newspaper and sales, and with the rise and radio, streaming, and the complexities of modern content creation and content marketing and entertainment. A lot of our listeners will probably be touched in some way by rights, clearances, online problems with websites, YouTube channels with claimed or unclaimed content. Our guest today is on the cutting edge of all of this. We are very lucky to have here to give us kind of a primer. It's going to be a very full 20 minutes.
Yeah, and as a manager, as a leader, your team might actually be, putting yourself at risk for liability without even knowing it. And a lot of that tends to be on how we use things like music and video and things that are other people's intellectual property because we've not checked to see if it's a copyright or in my case, a trademark. I've had a couple issues with that. Sell Smarter, for example, is one of our company's trademarks and has been since the turn of the century. And, we've had to defend that. So some people just instantly think if they keep, if that they're going to make that their tagline or something like that. Nope, sorry, it's already, our trademark. So I've experienced it firsthand, and it's very possible then for you to be very innocent about it, but actually be putting your company at risk. So we're going to talk about how to not put your company at risk.
Exactly. So welcome to Manage Smarter, everyone. We're so happy that you're here. My name is Audrey Strong. I'm the Senior Vice President of Communications at SalesFuel.
And I am C. Lee Smith. I am the CEO and founder of SalesFuel, which is a registered trademark of SalesFuel Incorporated.
All right, Stephanie Weier is our guest, the CEO and co-founder of Brandwood Global, an ad tech app company, as well as an expert with more than 25 years of experience in brand integration and legal rights permissions for film and television. An attorney and entrepreneur, her Brandingo app was out in 2025 this year. That is a solution, it's very interesting, that allows audience-empowered content and commercials to be silently and instantaneously delivered to customers based on their likes and purchase history in handling the payments worldwide. Stephanie, I don't even know where to begin. It's such a huge playing field that you play in.
Thank you, Audrey. Thank you.
So, I mean, out of, what is it? Patents, trademarks, copyrights, fair use, claimed, unclaimed. What is the most common issue that companies might run into that seems to happen more often than the other?
I think copyrights is probably the most litigious issue because it's artwork, it's visuals. It could be a recording like this, a podcast. And because the rights are with the rights holder as soon as it's created, even if they don't file it with the Copyright Office, they have certain rights immediately. This causes some consternation to people who want to create content that want to use maybe a backdrop that has graffiti on it, for example, or a tattoo of an actor. Those are things people don't realize. Those things are copyrights, and those can come back and haunt you, like the Hangover 2, for example.
How did you get into this line of work?
Well, I came from UT Knoxville. I graduated with a film minor and an English major. Wanted to be a writer, director, I think from infancy. Once I knew what it was, I wanted to be an actress first, and then I decided this was better. Are you there?
Yeah.
Okay. It just something popped up. Hold on one sec. Let me just start that. Sorry. It's so weird. Things are just happening. So I started off.
Let's go back and take that from the top.
Ooh, sorry. That's
okay. Here we go. 3, 2, 1. I'm wondering what got you into this line of business?
Yeah, so I started off graduating from UT Knoxville with the film minor and an English major in creative writing. I knew immediately, well, as soon as I saw She's Gotta Have It in high school, Spike Lee movie, I was like, forget acting. I want to be a director. This is awesome. So I was like, how am I going to get there from here? It just seemed so far away. So I went to DC, started working for the EPA as a video producer. And from there, transitioned over to Hollywood. And my very first job, as luck would have it, was Universal Studios, working for Lou Wasserman and Sid Scheidenberg, who were the heads of the corporate, which was MCA Universal at the time. We started doing a lot of marketing. And then just from there, I met my husband and learned about clearances. I was still on my track to be a filmmaker. I had made a short film, was totally broke, was temping around the studio, trying to figure out my next steps. And I just fell right into it and loved it. So doing rights permissions became my life. It's been very good to me and my family. And now that he's passed on, I've sort of carried on the legacy for him. And our company is still around. It's called the Domain Group. And now we're based out of Nashville.
Nice.
Wow.
So you mentioned the word clearances. What does that mean exactly?
Yeah, that's industry jargon because you think about air traffic control clearance, you're clear for landing. The same idea applies to content, but what it is rights permissions. So you're looking at anything that could be litigious for that piece of content, from copyright, trademark, and patents. IP law is really the space that's in.
So if I'm a manager in a job that requires a lot of content creation, or if I'm doing content marketing, my probably knee-jerk reaction will be, well, I don't have time to look up all this stuff and make sure that nobody else in the history of the world has ever blah, blah. Are there any best practices or simple, like a checklist of what I should be every single time looking at when I'm putting something out there?
That's a great question. My advice is if you don't hire a clearance company like mine to help watch your back, so to speak, if it's a short piece like a commercial or something, just make sure that your attorney reviews it. And hopefully, if they don't have the background in IP law, that they can get an outside counsel to review it. Because you want to have that piece of paper saying that there is no issue with your E&O, that commercial is free and clear to run. It really is surprising what comes out of the woodwork when you release something that does have IP infringement, because you may think it looks perfect and it may just be deep background, slightly blurred, but it's seen by the copyright holder and they will pursue it. And the judges almost always side with the copyright holder.
Right.
There seems to be some confusion over the term fair use. What is it and what it's not? And explain that to us. It's like, what is fair use and what is it not?
Yeah. So fair use it's like public domain. Those are terms that are very, they're like no terms in our world, because we want to make sure that the attorneys who are IP lawyers who litigate this are the ones really understanding what that means, because case law is really what decides what is protected and what's not. The copyright law and the trademark laws are very lenient, very wide, very vague, intentionally so, because they want the case law to determine what's appropriate and what's not. So fair use is really if you are shooting in a outdoor area and there's like 100 shopping trade names on the different stores, you're not intentionally, you're not being derogatory, you're not pointing out, you're not featuring, they're just in background use and they're equally represented, then a lawyer would probably say that would be fair use, because it's just a part of the open forum that you're in. Now, that is different than if you had a Kobe Bryant statue and you're shooting at a building in Chicago and they paid for that statue to be put there. That's not fair use. Even though it's in the public forum, you would say, well, why isn't that fair use? Why can I do that? Because you're looking at a trademark on a building versus a copyright. So a statue would be copyright protected. The building names, the H&Ms, the Zaras, those are all trademarks. So as long as you're not infringing on copyrights, you can get away with fair use a lot of times. Also, it could apply to dialogue. So it could be something like, oh, Britney Spears, I don't like Britney Spears. I don't like her. And somebody would say, well, that's derogatory use. You're hurting her trade name, her brand. But the thing is, you have the right to your opinion. So the First Amendment rights are really where fair use kind of comes in. There are certain rights that we have as American citizens that trump copyright law and trademark law.
What about music? So I remember when analog to digital started, remember Napster and how that was like really
Or
the
before that,
beginning?
we would record the radio right, on our cassette tapes, and we'd make mixtapes.
Yeah,
I had
right.
no idea. Yeah.
Music seems like the wild west of just, I don't know how you would keep up as an attorney with that space. Lee and I were talking before you came in the Zoom room, and one thing he said is, "Oh, I'm a manager and I have to do this live event for our sales team and prospective clients, and we run a hotel space and everything. Like, what kind of music am I allowed to play at that thing? Especially if
Right.
I'm capturing video of it to put on my Instagram." And the music's in the background. It's just mind blowing. Like, what are the rules of music?
That's a really good question, because if you are broadcasting in any forum,
Mhm.
Facebook streaming, whatever, that then becomes a commercial use, so to speak. So when you go from a personal use, like I'm just listening to it in my car, I'm at my birthday party, and my friends and family are hearing it, but now I'm actually posting it on different social media sites, then you become a commercial use. And so that those music pieces that are going to be heard do they carry forth, so you're infringing on those copyrights. And there are a certain amount. I met a music forensic person once who actually goes to court and fights for the rappers who want to use like Whitney Houston's song or something. They want to take a sample. So she was the one, she said there's a very strict formula that the court uses in music to determine if you are infringing. And that is, there's only a certain number of bars that can be heard.
Oh,
Once you
wow.
pass the bars, once you
Yeah.
pass the notes of that music piece, of past that, I think it's 4 bars of music. Once you pass that, then you're infringement land. So now the rappers have to license. So just like you and I would, they have to go and get permission to use that song in their song. So now they have a new copyright, right? They've created a new copyright that is ingested the old copyright of this other party. So now they have rights and the other party still has rights.
So Lee, the answer to your question additionally is the good old fashioned, I bought a music bed library catalog is what I can play at my event because I bought and paid for this music library. Just
That's right.
generic
Yeah.
production music beds, which probably would not be what you would want at your event, but it's safe.
Well, but yeah, the term sampling gets me thinking about,
Mm.
another hot topic, which is AI, generative AI, basically sucking down everything off of the internet and training these AI engines and everything like that. It's like, what's your take on that? Because it seems to me as a content creator, that they're taking my content. I'm not getting any benefit from it. I'm not even getting recognition that it's my content, and it's training something, that they're selling and making a lot of money off of, and I don't see a dime from it.
Yeah, it's going to be a burgeoning litigation field, I believe, because it's completely vacuuming up all copyrights, all trademarks, and then it's morphing those into new products, new designs. If you're a graphic artist working for a commercial and you need a quick logo for a t-shirt or for a background for a commercial you're going to shoot, and you just have an AI software that you're using for creating your graphics, and they use a lot. There's a lot of them now because they're so convenient. You don't know the sources because it's not going to be bookmarked in that AI. They don't go, oh, this came from here and this came from here. They just sort of dump it all into a big pot and just come up with something original, so to speak. So the way it works now for TV shows, at least that I'm working on and film, is the studios say do not use these AI companies to do your designs, because we don't know the source. We don't know exactly where it came from. And because they can still come and litigate on that, you're just opening up a can of worms. You really are. And that's the same for fonts too. A lot of people don't realize that font designs are copyrighted. So you definitely want to license your fonts as well, and make sure you have a license for that.
Like
How about
literally
something like,
everything,
well, like
everything.
something like Google fonts? Are you safe if you're using a Google font?
Not necessarily. I always look at the terms and conditions of every website that you go to. Look at that and make sure not only you're looking at it, but your attorney looks at it and reviews it, because there could be some weird little, it's for personal use only, not for commercial use. If you have to do this, you have to give a credit, you have to do something that you're not expecting to do. Don't assume it's fair use because it's on the website, any website. I had a situation come up on a TV show just a couple of days ago where, because the piece of art was public domain, technically, it's 75 years after the death of the artist. He died in 1918. So that would technically be out of copyright, right? But because a very private museum owned the likeness, this actual original painting, you can't rely on public domain. You cannot say that that's public domain because it is controlled by a company, a museum that does not allow it to be used without end credit, no advertising, signing an agreement, paying a fee. So you can't just assume, oh, Van Gogh, it's public domain. No.
Wow.
Certain pieces of public domain. If they're at the Met, for example, LACMA, they have very specific, if you go to the painting, it'll say public domain. Look at the terms and conditions and make sure that you're understanding what that says. And if you're not an attorney who's familiar with this, you need to pass it on to your attorney, because injunctions are the biggest nightmare for content. And that is where the copyright holder or the trademark holder can stop your content from being released into the public. And that can cost millions of dollars. Plus it tarnishes your name.
There's also this misconception that all I have to do is change a sentence, change a letter, change a certain font or a line in a logo or something like that, and now it's my original work. It's not, is it?
Yeah, that's kind of like the sampling, right? We were talking about, you sample Whitney Houston, put it in your new rap song. Do you own the rights to that then, because it's now ingested into your new project? No. So it's really false attribution. It's also infringement on their copyright. So a perfect example is, do you remember the Obama campaign slogan? He had that sort of red, white, and blue.
Yeah, that hope.
Cartoony. Yeah, hope and change, right?
Yeah.
Hope and change. So that was designed by Shepard Fairey, who is a noted graffiti artist in Los Angeles and other places. He did the Obey. If you saw the Obey, underpasses and stuff. So when that came out, it was everywhere. We all can bring that up in our minds. But the problem was, he did create that, but he did not use the photo, an original photo. He got it from an AP photo.
Oh,
So
wow.
Associated Press sued him.
Oh,
Copyright infringement, right? Because he changed it. But they recognized it. And he perjured himself on the stand. He said he did not, but he did. So it was a huge nightmare. But I will tell you what's ironic about that. Shepard Fairey is very litigious about his own graffiti art. So it was sort of like bad karma. But, that just shows you that, be very careful, because they're going to take it to all the way. If you're going up against AP, New York Times, you just have to be very careful. And that's why I recommend people, if you're going to go use stock footage of civil rights, go to Getty Images, go to iStock, license these properly so that you're protected. Really, you just don't want to fly by the seat of your pants if you're using anything out there for commercial use. If you're looking to make profit from this as a brand campaign.
Yeah, and the more money that you make or your company makes, the bigger target you are, because you have the money and they want some of it.
Absolutely. Absolutely. And the more more popular it is and the more successful it is, the more dangerous it is.
Right. Brandwoodglobal.com is your website. Stephanie, spelled, I guess, the traditional way, and Weier is Weier on LinkedIn, and Stephanie Weier.14 on Facebook, everybody. And so let's talk about Brandingo. You got that coming out in 2025. Explain what it is and why we need it.
Yeah, absolutely. So because I come from the Hollywood background of product placement and brand integration, that was really the next step. After I started doing clearances, people were like, well, since you're already getting permission from these trademark companies like Starbucks and Coke, why don't we just get some product placement? So that's how it sort of started. And then I became sort of an expert in that field because I started representing the brands on the red carpets in the films. And so my company was representing both sides. Product domain was representing the brands, and then clearance domain, at the time, it's now called the domain group, was representing the filmmakers. And I just was very defeated, actually, because I had very good success in getting both sides to come together. But you get into the legal side, it was just like everything got unwound rather, and redlined, and it just became a very nightmare situation. If there's any money on the table, it suddenly becomes very harried because you've got a lot of fingers in that pie. Also, you could not earmark where that money was going to come into the production, or was it going to go to the big studio slush fund. So the filmmaker was like, unless I see how this is going to benefit me, a Hennessy versus a Wild Turkey, why would I even change it? It's not benefiting the production. So what my husband had created IMDb for Universal Studios.
Oh, wow. Okay.
Back in the 80s. It was called Universal Feature Credit Tracking System, very long name. It still exists today. It's called Studio System, and it's Intel. It's basically the credits and how much people got paid on their contracts if they did a movie. But there was no way in the 80s for people to know, did you really work on arachnophobia, or are you just telling me you did, for example. So it was a vetting process. When Universal saw what they had, they said, hey, we're going to sell this. And that is what became IMDb. And then Amazon bought it for $400 million in 2018, I believe. But anyway, so he had that background. I said, hey, I'm very tired of this. I do it all manually. Is there a way we can come up with some kind of software that, with your background, you've been telling me you do this, can we do that? So that's what Brandwood started off as, is just a matching software for filmmakers and brands to come together for money deals. So we did beta launch. We had very good success, but we were still annoyed with the big question of ROI. How do I show that it worked to the brands? How do we prove, instead of just guessing? We saw, this many theaters opened. We're assuming this many sales, and that's always been the biggest problem with connected TV in general. But specifically for my use, it was just, if I'm getting a brand to come in for money, I need to show them it worked, so they come in again. And I just felt like we both felt that the industry was taking advantage of the brands, because it would say, come in VW for $250,000, and there would be no real delivery because the legal would tie it up. You can't have a still shot with the actor. You can't have this. You can't do press. And so it was very difficult. So with our technology, what we've done is we've sort of unlocked that. We sort of disrupted the entire industry because we don't need permissions to do this. It's a kind of a Napster idea, but with our Brandingo technology, what it does is it verifies and measures and tracks purchases in real time from connected TV, whether that's film, TV, broadcast, streaming, doesn't matter, podcast. And it's done through an audible sound that we have put a proprietary patent around. So we're not the first to the second screen you've probably heard of. People were trying to do this in the early 2000s, where they were trying to track, from what you're seeing on screen to your mobile device. So we've perfected that, I believe, and we have an MVP, and we launch with a YouTube integration this summer. So very excited.
Congratulations on it. Sounds amazing.
Thank you.
Very complex.
Well, it sounds complex, but at the end of the day, it's just basically allowing audiences to interact with content that they see on screen that traditionally has never been able to be tracked. So we allow them to just interact, but it also has high privacy engagement because we don't listen to them. We're only listening to our technology that we've embedded into the soundtrack. I see.
Okay. Well, if you want to hire Stephanie's firm, because I think everybody needs you, to be honest. I mean, this is such a crazy universe to operate on, and to be able to have somebody that's got your back. It's amazing. And then congratulations on Brandingo. I hope it's a smashing success.
Thanks for listening. If you enjoyed the show, please rate and recommend on iTunes, Overcast, or wherever you get your podcasts. You can also get more great information at SalesFuel.com.
This podcast is a part of the C-Suite Radio Network. For more top business podcasts, visit c-suiteradio.com.